Hello, welcome everyone. Good morning to those in the Americas. Good afternoon to our friends on the other side of the Atlantic, joining from Europe. And Daniela also, who's joining from Israel at this point. So thank you so much for joining us for this conversation today. It's my great pleasure to welcome you at this roundtable entitled Competition in Digital Markets, Comparing Regulatory Toolkits. So what we intend to do is really to discuss different regulatory initiatives with digital platforms in different jurisdictions. We know that these initiatives are underway in many jurisdictions. We have 3 of the important jurisdictions where these initiatives are taken off here today, represented. So Germany, European Union, the UK. Of course, there are others, but it's extremely important for us to have these debates moving forward and discussing these initiatives in different jurisdictions. Before we just start, a quick disclaimer here. The manifestations expressed by members of the staff of the Getúlio Vargas Foundation and by guests who participate in the events online represent exclusively the opinions of their authors and not necessarily the institutional position of FGV. We also reiterate that everyone present has agreed to participate in this event spontaneously, and with that, authorize the use of name, voice, and image, in addition to assigning copyrights related to their exposures for this transmission that later will remain on the official channels of FGV for anybody to watch. So to continue with this transmission, we ask you to express your agreement by verbalizing or just signaling your agreement. So thank you very much for joining us here today. And before we move on, let me introduce our stellar lineup of panelists. So first, we have here Professor Olis Andriuchuk. He's a computational law professor at Newcastle Law School in England. Olis' primary areas of experience and research focus on competition regulation in digital markets and the comparative perspective. We also have here with us Eduardo Gomes Casado, who serves as the case handler officer at the European Commission Digital Platform Unit, with a wide experience in competition matters in digital markets. Eduardo also holds an LLM degree in competition and IP law at the University of Liège. We also have with us Toby Rump, who is an antitrust and foreign investment counsel at Linklaters in Germany, with a long experience in handling antitrust and merger control matters before the European Commission and the Bundeskartellamt. Toby also holds an executive MBA from Kellogg. And finally, last but not least, we have Danny Seeliger, who is an antitrust and foreign investment partner at Linklaters as well, regarded as a leading competition lawyer in Germany with recognized experience in handling antitrust and merger control matters before the European Commission and the Bundeskartellamt as well. Daniela is also a professor at Martin Luther University in Halle, Germany. So thank you so much for being with us here today and for discussing this very important topic and bringing your experience and your insights about these new regulatory initiatives on digital platforms. So I thought we could start with a brief overview of these regulatory initiatives, looking at the different jurisdictions that are represented here. So what's going on in the European Union, what's going on in Germany and the UK, so that we can have at least an overview of the landscape before we dive into different questions here. So my suggestion would be to start with Eduardo, giving us a bit of an overview of the Digital Markets Act in Europe and how far are we in the implementation, just the broad framework of the DMA. Thank you so much for being with us, Eduardo. It's a great pleasure.
Thank you very much, Caio. Thank you very much, FGV, for organizing this event and for having me. Well, I will explain a bit in a couple of minutes the DMA, the Digital Markets Act, that we are now implementing in the European Union. So first, let me explain the context and the purpose of this law. So in the last years, we have been witnesses of a transformation of the economy. Now the economy is much more digital, and there is a concentration in these digital markets with a small number of large online platforms. So we have seen that there are many challenges brought by these digital players. And there are two main problems that we have seen, which are fairness and contestability. So we have seen that these large platforms are really behaving in an unfair manner vis-a-vis business users, vis-a-vis those companies that want to be present in their platforms. And also that these companies are so big and they have such an entrenched position that it's almost impossible, if not at all impossible, for other companies to challenge their status and to serve also as digital platforms in our economy. So that's why we have this law. We started, the Commission proposed this law at the end of 2020, and last year in 2022 we adopted this law, the Digital Markets Act. So we started just last month with the first milestone, which was the designation of gatekeepers. So I will explain what is a gatekeeper and what are the rules that we have in the DMA for designating gatekeepers. So in order for a company in the digital area, in one of the digital markets to be a gatekeeper, it needs to comply with two requirements. The first one is that they need to provide what we call core platform services. And in the DMA, we have a close list of 10 core platform services. You can imagine, for example, search engines, intermediation services. You will also have virtual assistants, video sharing platform services, social networks. So we have 10 of them. So this is the first requirement. And the second one is that these companies need to meet 3 cumulative quantitative thresholds. And each of these thresholds reflect one separate qualitative criterion. These qualitative criteria are, first, these companies needs to have an impact on the internal market. So they need to have a minimum turnover or market cap. The second criterion is that these companies need to act as important gateways for business users to reach end users. This is proved in the DMA by the number of business users or end users in the European Union. And the third criterion is that these companies need to have an entrenched and durable position or a foreseeable position. And this is shown by having the figures that I just mentioned in the last 3 financial years. So if these 3 cumulative criteria are met, and these criteria are met for at least one core platform service, then the company will be designated as a gatekeeper. So as a result of this, we have designated 6 gatekeepers, as I said, for 22 core platform services, but there is one exception to this presumption. So as I said, if companies meet these thresholds, they are considered gatekeepers, but the DMA provides for 2 exceptions. So even if a company meeting these quantitative thresholds, even if this is the case, this company can bring forward arguments rebutting that exception, because, for example, the service itself, even if it has a lot of business users and end users, it's not an important gateway for those business users to reach end users. And indeed, some of the companies have come up with this kind of arguments, and that's why we are now conducting market investigations in order to assess whether these services are indeed gatekeepers or not. And on the other hand, we have the other possibility, which is companies that don't meet the thresholds but still could be considered for other reasons as gatekeepers. And we also have one investigation into these kind of cases, which is the case of iPad OS, so the operating system of iPad. So, and also next year, of course, as I said, these requirements need to be met for 3 years. So it's possible that in 2024, new services will meet these criteria, taking into account financial year 2023. And if this is the case, then in 2024, we will have new notifications and possibly new designations as well. What does it mean to be a gatekeeper? A gatekeeper is going to be subject to the DMA, and we need to comply with a set of rules that are specified in the law. And when? So in 6 months. So 6 months from the designation. We designated the first wave of gatekeepers the 5th of September. So these companies will need to comply by 7th of March, because this is counted as of the day of notification, the day we notified the decision to these companies. And I will explain very briefly these obligations. So we have different obligations. For example, data-related obligations. So a gatekeeper cannot cross-use the data, the personal data of the end users across core platform services. So, for example, if a gatekeeper is designated for different core platform services, they can only cross-use and process the data if there is a consent from the end user. Another obligation, for example, is to allow site loading. For example, those gatekeepers that have been designated for operating system, core platform service, they will need to allow business users to have their app in the device through other means other than the app store of the gatekeeper. And also we have interoperability obligations, time obligations, and so on. So these gatekeepers will need to submit a compliance report in March, and from that moment we will start with compliance. We have different tools for compliance. We have RFIs, as we have in competition law. We have inspections. We have fines, and we have also market investigations, as the ones I mentioned, and also other potential market investigations in order to amend the text of the DMA, for example, to add more services, to add more obligations. But these, of course, need a legislative proposal. So this is more or less where we stand in the DMA. So I think for now it's enough. And then in the next topics, I will cover other more specific points of the DMA. Thank you.
Thank you very much, Eduardo. This is very helpful. So what we're seeing is really Europe moving to some type of asymmetric regulation, right? Identifying gatekeepers were going to be the subject of this new regulation that brings, with the designation of gatekeeper, these new obligations, and then force these gatekeepers to present compliance reports, and then to show that they're going to be actually moving to comply with these obligations that apply only to them and not to other digital platforms, right? Yeah. So let's move and look at Germany now. I think it's also a case of an asymmetrical regulation, but of a different type, if I understand. So let's move to our friends from Germany. Danny and Toby, please, you have the floor. We'd love to hear about the Article 19A of your competition law and what tools it brings for asymmetrical regulation as well. Thank you very much.
Yeah, and thanks so much, Kai, for having us here. We are very honored and pleased to give a small introduction into the German rules. So I have to say the discussions started slightly earlier, maybe, or in parallel to the European discussions. The ministry in those days, in 19 even, installed a competition commission 4.0, which thought about, well, how can we deal with the big digital platforms in the future? And ideally also in line and harmonized with the European laws. And we'll come to that in a second, because what they did is they started with the German laws and introduced in 2021, already at the beginning of the year, i.e. in January, with the 10th Amendment of the German Act Against Restraints of Competition, paragraph called, or the paragraph 19a, which you already mentioned. Now, the goal with this 19a was to allow the Federal Cartel Office to look at digital platforms early on. And in fact, before the European legislation came into place. And it was, or is, this 19a a strong tool for the Federal Cartel Office, and it allowed the Federal Cartel Office to initiate proceedings against firms which are or have paramount significance for competition across markets. And in German, the abbreviation you would often hear, and I mentioned it once because I think it's a nice word. It's called ÜMÜP, which stands for the German of paramount significance for competition across markets. So if you ever hear that, the FCO is dealing with ÜMÜPs, that's meant that you have really strong digital platforms. Now, under 19a, what is special is it's a two-stage process other than with the European Commission. First of all, you look at which companies are designated as an addressee. So which companies have paramount significance for competition across markets. And then secondly, only you have the possibility to issue specific prohibition decisions regarding certain types of behavior. And some of the behaviors which Eduardo just mentioned are indeed also covered by 19a. So for instance, that you are not self-preferencing, or what Eduardo also just mentioned is that if you exchange data, you need to get the consent of the users using such a digital platform. And that leads obviously to the question, when is the FCO and when is the European Commission at stake, and when do they have jurisdictions? Now, 19a, to continue, is special in that no dominance is required. It's ex ante, and it can be ex ante enforced. So it is 19a within the section on dominant enterprises. However, it does not formally require dominance. So that was new to the German legislation, that you can already below the threshold of dominance go against these digital platforms. And you can go against perceived abusive behavior prior, so even before the addressee has introduced such allegedly abusive behavior. And it is genuine competition law. So not like the DMA, a law which is outside the competition law rules, and therefore also the Federal Cartel Office in its core regards it as one of its core activities. And last but least, it's not self-executable. So the Federal Cartel Office has to designate the companies, and other than within the EU, the companies did not come forward to designate themselves. And they, once they are designated, as said, then the decision as such has to come in a second step. The scope of 19a is much broader than that of the DMA, and does not only cover real gatekeepers, but could potentially also cover all kinds of other companies which are really strong or have significant, or are seen as significant for competition in niche market, for instance. So it's not necessarily an overall big platform, but it can be also a company which just is in certain, i.e. in relation to data for pharmaceutical components, has a important share there. Passing over to Toby, maybe just to look at a couple of the cases, and we'll try to make that short and just as an overview.
Oh, and I need to unmute. And maybe one thing to add to what Daniela said is another difference to the DMA is that in Germany, we don't have these fixed thresholds where you can really designate as a party, okay, I'm an addressee of the DMA. You don't have that in Germany. In Germany, it's much more flexible for the authority. The FCO really has their some decision leeway to decide, okay, who will be an addressee, and they need to proactively initiate proceedings, and the factors that they need to take into account is dominant position on one or more markets. So you don't need to be dominant, but it's a strong piece of evidence that you are an addressee. The financial strength of a company, vertical integration is very important. Access to competitively relevant data is an important factor, and the importance of third parties' access to your platform is an important factor in that regard. So as Daniela already said, the German law entered into force a little bit earlier than the DMA. And since there were some uncertainties how this would be handled, the conflict between the DMA and the German rule, the FCO really started to hurry up, and they opened, or initiated proceedings basically against all the GAFA companies. I don't know whether you can still use that acronym because they have changed their name, at least a couple of them. And so we have proceedings against 4 of the GAFA, so Alphabet, Google, Meta, Facebook, Amazon, and Apple, where this first stage, this designation stage as an ÜMÖP has already been concluded. And where we are now in the second stage, where the FCO will decide on what actual obligations they will impose on these companies. And stage 1 is still running for Microsoft at this point. So I think now we've run through our 8 minutes. So Kaya, I think we'll throw the ball back to you. Thanks.
Oh, I'm back. Sorry for that. I think I had some instability in my connection here, but I heard you. You can hear me now, right?
Yes, perfect.
Okay, thank you very much. So thank you, Dani and Toby. I think this is extremely interesting. I think it shows a different strategy here, where the competition authority has new powers to designate certain firms as with a specific position of power across markets that needs to be addressed, but with lots of flexibility on which kinds of different obligations these firms will be subject to, right? So as I understand from the explanation, this is going to be defined case by case, right? So it's not that once you designate a firm under this broad umbrella of paramount significance for competition across markets, it doesn't attract immediately a whole haul of obligations, but the competition authority needs to choose which obligations to apply at that particular point. So very interesting as well to understand that. Thank you very much for that. And with that, please let's move on to Olis and to the initiatives in the UK. How you see that, Olis? I know that you've been following that very closely. So thank you very much for being with us.
Thank you very much, Kyle, Mario, for your kind invitation and for running this series. It's also my pleasure to participate in this panel with such co-panelists. I think we in the UK were and are united with our sister jurisdictions in terms of kind of negative objectives, what we wanted to overcome, which systemic obstacles to the effective functioning of competition in digital markets we witnessed. This very long procedures, very delicate pathway for ticking all the procedural box in terms of quasi-criminal nature of ex post competition enforcement, and thus requiring focusing on technicalities, on rather minor issues, instead of looking at more kind of strategic matters. So we were living in late maybe early 2000 through the period of continuous reports where different renowned economists, lawyers, data scientists, behavioral scientists were pointing out what's going wrong, so to say. And if you look at what different jurisdictions came up with, it also looks quite similar in terms of the vision. It also looks quite similar in terms of what systemic problems we want to tackle. But in terms of how we do it, there are obviously some some juristic differences. And the major question, which still somehow remains as kind of elephant in the room, what do we want from this? Because you see and hear different stakeholders pleading for different, trajectories of the development of be it DMA or German amendments to their competition laws or current UK Digital Markets Competition and Consumers Bill. It's still the bill, so it's still in the Parliament. But depending on who you listen to, you can hear that the main objective is to protect competition vertically within these core platform services or within what we call in the UK the conduct requirements. If we hear some people even refer to consumers, which for me makes very little sense. There are some who say that the main challenge or the main systemic opportunity with this new paradigmatic reforms in regulating competition in digital markets would be triggering competition horizontally, not in a kind of vulgaris, kind of caricaturized sense, trying to promote our domestic suppliers of these strategic digital services, core platform services, but maybe at least to facilitate new entry, maybe making this new entry more plausible, at least hypothetically, because there is not much we can do in terms of promoting some companies, but at least we need to open up the kind of hermetically closed, hermetically sealed doors to these really important markets. So when we talk about the UK, I think the model which the legislators are aiming at is very similar to what we have in Germany. It is not a sui generis competition law as DMA is often positioned, because I mean, on one hand, we understand that the intellectual pedigree is competition vision, so to say, but technically speaking, it has different objectives. It has different even task force or directorates which will be dealing with these issues, and also it's enough to attend one or two stakeholder workshops organized very helpfully by the Commission to hear that the Commission aims to emphasize that even if the cases come from the intellectual background comes from exposed cases, successful or not, it's a new start. In the UK, it is slightly different, so it's kind of a continuation of competition law, and we also have vaguely similar two main approaches to it: fairness focused and contestability focused. What is very similar to the German equivalent is that we have undertakings designated with strategic market status. We have our own abbreviation, SMS, undertakings with strategic market status, and then imposing upon them conduct requirements ad hoc, pretty much. So it's a very bespoke system where we can tailor, where the Competition and Markets Authority can tailor obligations and impose upon different undertaking USMSs, we call them, depending on what specific challenge is being envisaged or attributed to each specific undertaking. So in this regard, it is more similar to what we see with Section 19A. But I also think that in one of the iterations of the discussions, the bill was called, or the reform was called, New Pro-Competition Regime for Digital Markets. And we, at least in academic cycles, we get somehow puzzled. Maybe it's important time for us to reopen the never-ending discussions about the goals of competition law, and mainly not necessarily limiting ourselves to this preventative modality where enforcers are being akin to policemen and women who scan the markets in order to identify instance of infringement and then to remedy it ad hoc again within, and then the procedure lasts for ages, etc. It's more proactive approach. We want to create pro-competition regime. And now the largest question, I think we witness all these jurisdictions which are in this developed more at the level of adopted acts what do we want? What kind of competition would satisfy our enforcers' vision, so to say? Because at least in the UK, it looks that the discretion for designating undertakings, as well as the discretion for tailoring conduct requirements, the sky is the limit. And I, being very pro-enforcement person, I applaud and endorse this system, but the big competences, carry also big responsibility. Now the question is, what do we do with this, unexpected avalanche of discretion which the competition enforcer, at least in the UK, is likely to receive? Plus, it looks that we will only the decisions of the CMA will be only subject to judicial review, which is a very limited scope. So it's not full merits review, it's only judicial review where only procedural aspects might be. We know it's not to undermine the opportunity to challenge this decision. History tells us that every comma, when billions are at stake, every comma can be interpreted in one way or another. And we have precedents in the UK as well, quite recent. But obviously, it limits the scope for questioning the validity, the prudence, and the meaningfulness of the decisions of the CMA. I pause here at this point.
Apologies. I think my connection is unstable here, but can you hear me back?
Yes, we can.
Thank you, Olis. I can hear well, but it's sometimes when I'm going to speak, connection here. I'm trying to solve it, but let's move forward. Thank you very much. I think this issue of flexibility versus discretion is quite important as well. I think in thinking about these issues, we need to understand. So I think I'm back. Can you hear me? I'm sorry for that, really. So let's move to the next round of discussions here. Like as we see, like different approaches, some more flexible in designing the new regulations, some less flexible, but either way, trying to address companies that have a particular power, a particular position in different digital ecosystems, right? So this is really what we're looking at here. Now thinking about these different strategies and thinking about whether there is more convergence or divergence or even potential conflict in some of them. So we're talking about like a broad strategy in Europe. We're talking about specific strategies in different jurisdictions. We're looking at Germany as a part of the European Union with its own strategy. We're looking at the UK with a separate strategy and post-Brexit, an important jurisdiction that's going to be outside the EU, also signaling how to deal with these issues as well. So I'd like maybe to try to compare a bit how you see these different strategies and how to compare the pros and cons and the challenges of these different approaches. And maybe you could start with Olis, who recently tried to do this comparison between the DMA and the UK bill, and what would be like advantages and disadvantages of each one of those. So Olis, maybe you can kick off in this discussion, then you can hear from our other panelists. Thank you very much.
Thank you very much. I think it's really interesting. We agree there is a consensus in terms of the objectives of these legislations in these three jurisdictions and maybe some others as well. But obviously, when we look at technicalities, then each jurisdiction chooses its own way, and clearly this comparative analysis should be done with two important caveats. First of all, whether the chosen trajectory of development is good or bad depends on the normative position of the author. So I will be doing this kind of reflections based on my normative vision is that the more, we somehow approach inevitably to this invisible red line dividing liberal democratic societies from somehow, micromanagerial authoritarian approach to, or planned approach to the markets. And the skill, the craft of this new reform is to approach closer to this red line without crossing it, because it will be somehow against the very DNA of liberal democracy. But more interventionist tool is the only way to start this journey. We need more intervention, because if we just rely on axiomatic rules, as we were doing for the last decades in ex post competition law enforcement, we shouldn't expect significant changes. We could remedy sporadically some problems here and there, but the objectives are much more ambitious here. And so with this in mind, I started doing this comparative analysis. And also, obviously, the second caveat that we are talking about the bill. So the bill is currently in the parliament in the UK, and what has been seen as an obstacle might be changed and turned into advantage. And so this is also an important caveat. We're not comparing like with like in terms of where we are in terms of the validity of the act. Now, what looks to me as an important advantage of the DMCC bill, the UK bill, is that it grants greater flexibility to the enforcer. With some caveats. For example, when we talk about designation stage, there is some really, I don't know, esoteric provision, which I just cannot comprehend. Maybe it's my myopic perception of this provision, which requires, in order to designate undertaking with strategic market status, the CMA has to conduct forward-looking assessment in order to look 5 years ahead. You look 5 years ahead in order to confirm the entrenched, or passive tense, past tense, in order to confirm the entrenched market status already. I just understand. And then how you will be doing it, what would be your counterfactual? 5 years in digital world is like eternity, next to eternity. All other designation criteria in comparison to the DMA are much more softer. So we talk about digital activities. So we're talking about pretty much everything which you do online can be qualified as a reason for us to intervene. And also all other quantitative thresholds, which we look at, if you look at the DMA, are much more flexible. They give much greater flexibility. Also, what is even more impressive, because we were uploading to the DMA. I don't know, Eduardo, please pass my salutation to the person who came up with the vocabulary of Article 6, the very title itself. For me, it's like the craft or obligations susceptible for being further specified. It's not that we don't have time to specify obligations. We want to specify them pretty much ad hoc, or depending on the rapidly developing markets. In the UK, we went even further than this. So we don't constrain the CMA with the pre-listed, however rich the list might be, pre-listed catalog of obligations. We give them the power to tailor obligations for each specific undertaking with strategic market status, which would help to deliver this kind of fairness related obligations. In other words, you receive carte blanche to design your obligations, but on the other hand, we don't have in Europe what we have in the UK, namely efficiency defense. It was, you probably remember during the discussions on the DMA, it was the main kind of those who were promoting the kind of less powerful DMA regime were talking, look, we need efficiency defense. What if the intervention is already too high? What if this conduct is efficient? If you go for efficiency defense, it can paralyze the entire effectiveness of the reform, because if we can find efficiency defense for hardcore cartels, when so much is at stake, you can find efficiency in much more innocent obligations, because these obligations, most of them at least, are not subject to ex post competition rules because they are normal. So it's a normal conduct. In this sense, these new rules are punitive because they impose this additional burden on gatekeeper USMSs or these undertakings, because that's the only way. That's the only way to recalibrate, to reanimate competition in digital markets. And again, we don't have confidence if you succeed, but at least we are trying. So if we start giving them efficiency defense, they can justify pretty much all obligations. That's why DMA very prudently, the legislators, co-legislators of the DMA very prudently avoided this pitfall, which is not the case in the UK, at least now. We see so-called contravening benefits exemption, where the designated undertaking can demonstrate why the conduct why not compliance with the conduct they are being requested by the CMA to comply with is beneficial, brings benefits to consumers, and all this kind of traditional vocabulary of efficiency, etc. Which I cannot square how it can work with all much more proactive, much more ambitious mechanism of the DMCC. And when I hear it from in different conversations from colleagues who propose to keep it as it is basically that, well, jointly with judicial review, you would not be able, the CMA would be able to say, well, we looked at the deficiency, at your attempt to justify a conduct, but it's by far not enough, and you cannot, it's not justiciable, the decision. And if subject to very procedural, purely procedural grounds, if this is the case, this might work. But I just struggle it works a little bit in dissonance with the very ethos of the DMCC bill. So efficiency defense, in my view, should be, or I mean, I should stress mandatory efficiency defense. The CMA now in the bill we have mandatory. If we do it discretionary, then it obviously turns from the obstacle to the advantage, because it contributes to the regulatory dialogue. So we can sit at the table and engage in this, participatory antitrust, which we all were so excited with, and saying, okay, if you are willing to do this, we as enforcers are happy to turn a blind eye to other practices, and thus we can accept this if you continue doing B. So it's kind of more engaged, much more micromanagerial stuff. And when I mentioned blind eye, I think for me it's a proxy to stress that these rules must be enforced centrally. So it's purely public enforcement, which makes sense to my understanding of things. I know that the rules themselves open the door, and it's hard to avoid, open the door for private enforcement. But I would say that private enforcement is likely to be a Pandora box, because when you have 100,000 business users, each pursuing their own vision, then we can somehow we get lost in about what do we want to achieve. And the ability to turn the blind eye, the ability to show the stick on the wall, but not to apply it, but apply it very, very, delicately and only when it's really needed, works as a good disciplinary function. So I think this modality would allow the enforcers so much needed flexibility and sitting and waiting when the gatekeeper starts knocking on their doors, as opposed, as it was the case, the opposite case in the past. At least that's the metaphor which has been used by Andreas Schwab, one of the main protagonists of the reform in the EU. So I pause here, but I have other elements which require attention. So if there is time, I'm happy to continue.
Thank you, Olis. I think the discussion about efficient defense is particularly interesting. I think there may be cases where maybe Eduardo.
Yeah, thank you, Caio. Well, first of all, thank you very much, Olis, for your paper. I found it very, very interesting and insightful. So first, let me share with you what I think is well, I said before, the purpose of the DMA and digital regulations. We have seen that in the past, antitrust enforcement in the digital markets have been very active, but it's true that digital markets are really, really evolving really fast, and we needed a new tool to be more efficient and more effective in a shorter period of time, with leaner procedures and with more targeted rules. So that's the reason why we have this text that we have now, the DMA. So I will go through the main differences of these different regulatory regimes. So indeed, in the European Union, we opted for a closed list of core platform services, of obligations, also these quantitative criteria that are really specific, and these criteria are not subject to any kind of interpretation. So it's what it is. But we have, as I said, this rebuttal mechanism, but you have the rules. It's really clear for gatekeepers and for other third parties. So we thought that since the procedures are going to be more light, let's say, yes, in order to speed up things and to make to see results happening more quickly, we had to give gatekeepers that are of course bound, and they are really subject to really strong rules. So we give them the legal certainty, so they know whether they are going to be subject to the law, what they really need to do. And so that's why we decided to balance the text in that sense. So on the one hand, we have these procedures that are really light, and on the other hand, we have these rules that are really fixed and that gatekeepers know in advance what they need to comply with. And then on the efficiency defense, well, we have the specification dialogue, which is what Oles was saying for Article 6 of DMA. So for some obligations, for specific kind of obligations, we give the opportunity to further specify the scope of these obligations, and that's a formal mechanism, so a formal procedure. There needs to be a formal dialogue between gatekeepers and the Commission, finishing with a decision, which is subject to judicial review. But I don't think, well, this is of course my opinion, that efficiency defense is really relevant or really appropriate in this kind of regulations, because we are talking about gatekeepers, about really big, large online platforms, and so everything they do is going to have a huge impact on business users, on the market, on end users. So we know that these rules are per se are bad. So these rules are the origin of the position of the gatekeeper. So if gatekeepers continue pursuing this behavior, they will have a more and more entrenched position in the market. So I consider that, I mean, in antitrust is different, because in antitrust we are talking about dominant companies in different sectors, and of course there may be some, and we have seen in the past that there are some efficiency defenses, but in this case we have that some rules that are applicable automatically, and of course we can discuss with gatekeepers what's the scope, because of course we have obligations, but every core platform service is different. So of course we have to see how to comply with a specific obligation depending on the core platform service that we are talking about. And then on the procedures, as I said, I think it's good to have these procedures we have, because we have, from our antitrust experience, we have seen that large platforms or large dominant companies in other sectors, they play with the procedures. So the more procedural steps you have, the more opportunities for the investigated companies to play with these rules. So I think this is a good mechanism we have. This is a great advantage of the DMA, and well, I think it's gonna work well. And yeah, that's mainly my point. And also, just to bear in mind, we have to bear in mind that all the decisions we adopt in the Commission are subject to judicial review, and of course we are foreseeing a very light procedure, but we have to give companies some certainty on what they need to have in order to be gatekeepers and what they need to comply with in order to meet the different rules specified in the DMA.
Thank you, Eduardo. I think this is really interesting. I think the search for certainty and for legal certainty especially it's certainly important. The big question is whether losing flexibility can be also an issue in some of these markets. So maybe let's hear also how Toby and Danny think about that and this perspective, and also on the efficiency side. I mean, even nations that are efficient, right? So let's hear.
Yeah, thanks a lot, Caio. I would start maybe from the German angle and quickly point at two cases where, in fact, it has been disputed to what extent 19A and the DMA exclude each other or not. So the one case, which is actually decided by the Federal Cartel Office, likely in the next couple of weeks, is the Google data processing case. And there, the Federal Cartel Office was looking at how consumers had to give consent when using the various Google services. And the Federal Cartel Office thought that, in fact, whenever a consumer was using a Google service, they should consent to the use of all other Google services. So not just the core Google services, but in fact, all services, which amount more or less to like 60 or 70. Whilst under the DMA, obviously, there are certain core platform services which the consumer needs to give consent to so that Google can use its data for the other services. And if I understand correctly, it's more or less 8 services. So there's a delta of around 50. And obviously, then the question is, well, is the Federal Cartel Office and 19A essentially, is the FCO allowed to look at these non-core platform services, or are they already covered by the DMA? Because once they have been appointed by the DMA and the European Commission as core platform services, that meant everything else should not be included. And that obviously becomes in particular importance if you look at all other member states, i.e. 27, if they all were to come up with their own regulation, what is a core or non-core service, then all of a sudden the big companies would likely look at a landscape, maybe a mosaic of very scattered decisions. Now, I assume this case in the end might be settled, so then we will not necessarily know what exactly is the scope of 19A and the DMA, but there are some other cases. And the second case I quickly wanted to allude to is Amazon, because they are just going to the Supreme Court and they fight against the designation decision of the Federal Cartel Office. And they argue once again that in fact, the Federal Cartel Office should not have the power to designate anybody as UMUB because everything is covered by the DMA. And also there is a conflict with the transparency directive. So the national legislator has to notify whatever they do in relation to gatekeepers to the EC before adopting any decisions. And I think there we will likely get a decision, and also maybe not too long down the road. Because what also was new, and that goes to Eduardo's point of it taking very long if you try to procedurally fight with these companies. In Germany, we have no longer a 3-step court approach. The Court of Appeal was taken out, and it's right now goes directly to the Supreme Court if you fight against your designation decision, to make the whole process much quicker. And I pass over to Toby, maybe to add.
Yeah, maybe with regard to the efficiency defense. So Section 19A doesn't really provide for an explicit efficiency defense. However, if you look at the actual prohibition decision, so the conduct that the UMUBs will not be allowed to do anymore, there is a way for them to provide a factual justification of why the things that they are doing, the service they're providing in the way that they're doing, are justified. So in that regard, of course, they have to shoulder the burden of proof, and there they could introduce also efficiency considerations. However, here, as always already said, or alluded to, the FCO itself has a level of discretion. So they can say, okay, yeah, we accept this defense, and it makes sense that you want to continue in this way because it's an essential part of your business model, and it's really necessary for you to do that. And you also create efficiencies, not only for yourself, but maybe also for consumers or other stakeholders. However, even if they don't accept it, we again have this in front of the courts, and the courts will have to decide on these arguments that the UMUs are bringing forward. So we will have to see to what extent efficiency defenses will be accepted by any of the courts. So far in Germany, I would be rather skeptical, just from like the traditional way that German antitrust law or competition law has dealt with efficiencies, and I don't see this as a great game changer in that regard.
Well, I think that as Caio is facing some instability problems, I will take over here and conduct the rest of the roundtable. Well, based on that, I think that we could go to the third round of our conversation and basically better understand here in which sense that these initiatives mean something for competition policy in general, as a form of transformation, as a form of particular regime. So I think that Daniela or maybe Toby could take the floor on this debate and go further here.
Toby, would you like to start?
Of course, but I first to set up my things here. So yeah, what this means to competition policy in general, I think can be seen from the various statements that in particular Andreas Mund, who is the head of or president of the German FCO, has made in the last not only months but years, all up to the day that the DMA was actually released. So we have, as we discussed like in the first part here of the panel, this conflict between the DMA and the different national rules. And I think that will still go on from a policy perspective. In that regard, we also have this interesting, not only conflict, but the difference in regulatory regimes. So we all know that the DMA is not real competition law as such, because it was just not possible to create a competition rule due to the legislative process at the EU. So they had to create a genuine new tool. And there we have other countries or jurisdictions such as Germany, where we have something that is genuine competition law. So how do you match up these two against each other? And that is also interesting, probably from the perspective of the GAFers or the gatekeepers or UMIPs or whoever you will call them. How will they react to this? So not only to these different kinds of regimes, but also with regard to their own business conduct. So, I mean, the reason why this was all introduced in the beginning was that people thought that traditional competition law was maybe not efficient or quick enough to react to the development on the digital markets. Will this now at all change? Will they change their conduct? Will they change their approach? Will this just maybe also, if you do a negative outlook, be either positive or even negative for innovation in Europe and what will happen here? Or will they all just move out of Europe and see whether they do more things in Asia or in the US? And yeah, you want to say something?
Yeah, no, just to add to this, I really think that's a very interesting topic to see how globally this is all going to play out, because now we have regimes in Europe and within Europe on the national member state level. But if you look then at the US or also Asia, there is not yet such coherent system in place, and so that European companies and the other way around are not at a disadvantage, and it doesn't get too complicated for the companies. I think it's also something to bear in mind. And on the other hand, if you look at the broader political landscape, the second thought maybe is for the Federal Cartel Office, it has really been one of the first topics where they look at consumers also, data protection and all of this, and data protection being seen as something which belongs to competition law and should be protected. And so what you can see or feel is that also with ESG topics, all of a sudden they go beyond mere competition law, as you would have defined it 15 years or so ago, but they broaden the scope as such to include more and more consumer-focused goals. Thank you.
Thank you, Dani and Tobias and Arthur for filling in, given the instability here. Thank you very much. So let's move to Eduardo, and like this, I think this broader question is one that is quite important as well. I mean, what's really the impact of all these initiatives in the development of competition law more generally, right? I think that's is it really changing the landscape deeply? Is it going to change how we apply competition law to other markets as well? How do you see that, Eduardo? Thank you very much.
Thank you. So, well, first of all, let me remind you that, of course, data regulation is something different from competition law. Of course, competition law was an inspiration for the obligations in the DMA, in the case of the DMA. But we always say that competition law and DMA are complementary tools. So the DMA, as I said, was created because we had the need to regulate ex ante certain behaviors of digital gatekeepers. And we need to have these rules applied automatically without going through the antitrust proceedings, which are really, really a hurdle. So this is not new, this complementarity between competition and regulation. We already have this before the DMA with energy regulation, with financial services, with telecoms. So now we have a new sectorial regulation, which is the digital regulation. And the focus for each instrument is the following. So the DMA deals with specific behaviors of gatekeepers that provide core platform services, and Article 102 of the treaty will still be applicable in 3 instances. So the first one is those abuses of dominance by dominant undertakings that are not gatekeepers. Second, those dominant undertakings that do not provide core platform services. And the third one, gatekeepers that pursue behaviors that are not covered by the DMA. So these instances in which 102 will still apply is going to be an important tool for DG Comp and for the Commission to tackle these certain behaviors. And this enforcement of competition law in the digital sector will also serve as an input for the DMA, because the DMA will be reviewed every 3 years, and depending on new developments, new obligations and new services can be included in this close list that I was referring to. And of course, well, this complementarity was also confirmed by the Court of Justice, saying that competition law can intervene to complement regulation. In B-Post, they said that. So as to Caio, as to your question on what's going to be the impact of the DMA on competition law enforcement, well, first, as I said, both instruments are going to feed each other and are going to inspire each other. But also, I can imagine that since most of the issues are going to be dealt with by the DMA in the digital sector, there will be maybe fewer cases in antitrust enforcement in the digital sector. And this will have an impact on other sectors as well. Because, for example, in terms of the European Commission, I can see in the future that since we are not going to have so many cases in antitrust enforcement in digital sectors, those resources can be allocated to cases in different sectors. So that's the impact I can see from my experience. Thank you.
Thank you, Eduardo. I think in a more parallel perspective, right, of the two enforcements in the dialogue with each other, but like in different spheres of action. I think this probably more so where you have like these separate tracks for this than when you have like the same authority. Of course, you have the European Commission dealing with both, but you have some separation there. But when you have the Bundeskartellamt like applying both, then you have a different kind of interaction happening there as well. But let's hear from Olis here as well. What are insights on this issue of this changing landscape here, Olis? Thank you.
Yeah, I think I concur with everything which has been observed by Daniela, Tobias, and Eduardo, as well as yourself, Caio. Just wanted to add maybe one or 2 points. Well, when we talk about implications, obviously there is a technical route when we can. Some challenges might emerge with such principles as non bis in idem, for example, and. One can see how it can be somehow shaped in this vocabulary, but many people would disagree, of course, as well. But also when we talk about, purely, conceptual side of the story, when we look at it, in the European Union, we were considering new competition tool when the reform was just introduced. So one of the possible trajectories was to develop this kind of more comprehensive proactive mechanism for all areas, but we opted for digital, more narrow, where these changes were the most urgent, so to say. And it's not to say that the other sectors of competition policies are being conserved in the kind of Chicago orthodoxy. The competition world is changing very quickly, and it absorbs these changes in all sectors, not only in digital, but digital sector epitomizes this trend best. What I also noticed when having conversations with colleagues from jurisdictions who are considering this similar reforms in their own countries, what I noticed that the discussions are often stuck on the issues: do we need them or not? And it looks that most of their intellectual energy being wasted on this, questions which are either self-evident, or you can just look at 2001 discussions in UK and EU and see how many arguments have been rebutted and how many discussions have been or energy was burned for this question. If you don't need it, just don't introduce this initiative. If the initiative is introduced, it would be much more prudent and much more efficient to focus on issues which are really matters, rather than discussing the normative nuances and the responding to the arguments that more evidence is needed. We can hear it, and it's like really surprising how these messages deviate conversation to the very unproductive avenue. The last point, what is really interesting, what we will be witnessing, I think, and I'm not alone here, and probably I echo Christina Kafara's point there, that the majority of new competition we will see between different ecosystems. So they have this remarkable ability to transform whatever legislation we impose upon them to their benefits, and they will be somehow using DMA instruments as well as DMCC Section 19A, etc., to their own benefits, directly or indirectly, trying to enter into each other's market. And this will be, from the orthodox point of view, this will be a healthy competition, because if seven largest companies compete with each other, trying to enter into each other's market, they will deliver all the benefits. But then the normative question: is it the only incarnation of competition which should be interested? Should we endorse it, or should we just tolerate it? Should we see it as a side effect? Because otherwise we turn them into quasi-public utilities. If we don't challenge their status quo, so to say, they will become, the quasi-public undertakings with all implications, good and bad, on our markets.
Thank you, thank you, Olis. I think this is, I mean, this is really a rapid moving landscape. It's still hard, I think, to understand all the potential interactions, and also I think we need to think about like all these new initiatives happening in parallel in many different jurisdictions. And maybe one of the things that I've been thinking, like from the Brazilian side, is rather like seeing the challenges of enforcement in Europe, for instance, learning with what's going on there first before we even like start moving in any direction like that could be a great learning opportunity here. I don't see as a game where if every jurisdiction starts quickly moving in the direction of regulatory tools, that this is going to be the best outcome possible. To the contrary, I think it can be in a very messy and complicated world globally where it may actually hinder innovation and hinder efficiency to some level. So we need to think carefully on how this interaction is going to develop here too. But then let me move to these enforcement aspects, right? So if we can talk a little bit more about that and spell that out a little bit more. I think we heard a bit on the challenges both in Europe and in Germany on how these procedures are going through and identifying these firms that are going to be subject to these new tools, and then identifying the obligations, understanding how the compliance will be, and moving forward on this. I'd like to, if possible, to spell out a little bit more, what are the challenges? What are the difficulties? Where is going to be the issues or the key issues that are being found in trying to apply these new tools so that we can understand more not only what is desirable, what is intended, but also what are the challenges in applying them and enforcing them. So maybe we could go back to Eduardo and hear more about the DMA first, which is really currently in the forefront here, and then Germany and the UK as well, so that we can understand where we are in this and what we're learning with the difficulties of applying these rules. Thank you.
Yeah, thanks a lot, Caio. So as you all know, the implementation of the DMA has just begun, and we are now discussing with gatekeepers to prepare for the enforcement, which will start in March next year. So I guess it's a bit too early to have lessons learned or to identify challenges, but yeah, I will try. And also, I think we have a very good text. Text in the DMA, which is very flexible. Of course, we don't have the flexibility that the bill in the UK has, for example, in some instances. But we have this flexibility that I was referring to before, which is that in 3 years' time, we will be able to review the text and to change the things that we think should be changed. But as regards potential challenges, well, it's true that, for example, in terms of resources in the Commission, it's true that we were asking for a large number of people, and well, during the negotiations, for example, we proposed to have 8 core platform services, and in the end, after the negotiations, we had 2 more, but we didn't have more resources as a result. So this is something that could have been done differently. And of course, it's going to be a challenge because we are talking about a lot of work. We are talking about a lot of gatekeepers, a lot of services, a lot of obligations, and this is be a challenge. Another challenge I see in our enforcement activity is the asymmetry of information, of course, because well, the DMA is very clear that the burden of proof is on the gatekeepers because they are the ones knowing best about the technical possibilities, about the limits of their businesses, and they know much more than we do. So this is also a problem that we have. So that's why we are engaging from, I mean, this is nothing new, but we started even before designation with the potential gatekeepers to discuss compliance. No, so we have already mapped which obligations are applicable to which core platform services, and on that basis we are discussing with gatekeepers. We are also using third parties because, of course, they know a lot about these markets and they can give us a lot of useful information. We have also organized in the past workshops on different obligations, so this is also another tool we have to bridge this asymmetry of information. Also, the regulatory dialogue that I referred to a couple of minutes ago, which is also a process that we have in order to discuss how the obligations can be complied with by the gatekeepers. Also, of course, our experience in the antitrust enforcement is going to be very helpful for this, and also the experience of national competition authorities. Another challenge that also I mentioned before is gatekeepers playing with the procedural rules, but this I think they have a limited scope for this because the procedures are really slim and they don't have much margin. And also there is a debate that I think is very interesting, and it's whether because imagine, of course, the objective of the DMA on digital regulation is to open up ecosystems, to create opportunities for businesses, and for end users to have real choice. But what if, imagine that with our enforcement of the DMA, we have a space in which businesses can enter the market, they can challenge gatekeepers so that there are more opportunities. But what if end users in the end don't take up these opportunities? So what if markets are contestable but are not contested? So this is something that we will need to see in the future, whether our enforcement is not really effective to ensure the objectives of the DMA. We will see in the future. Another challenge is gatekeepers potentially trying to circumvent our rules, but we also have an anti-circumvention provision in the DMA. And also we have this potential problem of inconsistencies between regulatory approaches. So what if, for example, we are dealing with data in the DMA, so we cannot have an inconsistency between the DMA and the GDPR, for example, or the same goes for consumer protection. And also in the same with the same philosophy, what Daniela was saying about different jurisdictions dealing with similar problems. But this I believe, and I'm very confident this will be solved with coordination and cooperation with other jurisdictions, which has been the case also for antitrust, for mergers, and we have seen also other jurisdictions outside the EU, apart from the UK, that are that have already, or that they are going to start regulating these markets. So overall, these are the challenges I see in our enforcement, but hopefully most of them they have a solution. Thank you.
Thank you very much, Eduardo. And I think, I mean, if markets are contestable, but they're not actually contested, and like these firms remain like the first choice of users, I mean, this may be a signal that of efficiency, right? And of customers actually enjoying that. And as long as it's contestable, it is still pushing for innovation, right? It's still pressing firms to actually innovate and remain attracting consumers. So that's one thing that I think we need to watch, and I think it's an interesting point. So not necessarily the fact that it's contestable, it means that other firms are going to emerge in a very relevant way, but it may mean that competitive pressure is going to be there. And so this is one potential discussion that I think is quite interesting. So let's move to Germany again. Danny and Toby, please.
Yeah, and I'm very happy to start with a small point, which is to some extent obvious. The Federal Cartel Office obviously only has jurisdiction for Germany. So when they try to prohibit a behavior, or when they agree on remedies or impose remedies in a 19A case, then normally it would or should be limited to Germany. On the other hand, obviously with the platforms, everything is often so intertwined that you can't really distinguish. So I think that's a real interesting point, and I wonder how these jurisdictional issues will in the future become a point of concern, and whether these will in fact at some point be decided by the Supreme Court. So far, often companies don't challenge them. So if you compare it to merger control and other also national versus EU cases, you might have to some extent the same issues. But I could see that this happens here, and then I guess it's going to be really interesting how the courts will view that and decide that point. And maybe over to Toby once again.
Yeah, I mean, with regard to the enforcement, maybe we don't just look at the challenges, maybe look also at the evidence where the new law might have helped the FCO indeed. So not all of the cases that were so far introduced or that the FCO has launched have initially been launched as an Section 19A case, so under the new regime. There were some legacy cases, in particular with regard to Amazon and Facebook, where they had initially started just traditional abuse of dominance proceedings, and then just added this 19A prong to that. And I think the FCO would tell you, oh, we made very good experiences with that because we were able to accelerate the proceedings dramatically, because it was a new tool. Also, probably the companies were in new waters in that sense, and we're much more willing to discuss solutions with the FCO. And so in that regard, in particular with Facebook, they reached a solution and a settlement very, very quickly. And the FCO exactly got what they wanted. They did not conclude the investigation at that point because they said, okay, we want to look at some other aspect as well and see whether after this designation decision, we want to capture not only this Oculus or Quanta, whatever these VR goggles are called. We also want to look at the data used by different Facebook or Meta platforms. But I think they would say, okay, that was very highly efficient, and we were able to conclude this quickly. And only 2 of the cases were actually challenged so far. So it's from the FCO's perspective, I think it's a good success so far. And now they only have to see, okay, how do we handle the situations that Daniela already mentioned before, where the DMA now kicked in and designated some of these companies as a gatekeeper. Where can the FCO still find their little niche where they can still continue with their enforcement, claim with their big claim to be one of the what they say most prominent digital enforcers in the world?
Thank you. These are all very interesting insights on German experience as well. And maybe what we could do, I think we have a few minutes left before we close, is move to a couple questions that we of questions here. So one question, I think we touched a little bit upon it, but I think it's worth like having a deeper dive. So the question is,
maybe if I could jump in. The first one is, understand these regulatory initiatives as transformations of competition law in a broader sense, as we have already talked here. could we expect their extension to traditional markets, or at least non-digital ones, or non-digital dimensions of those markets, as banking or as other kinds of traditional industries? And the other one is like, how can we ensure the effectiveness of especially nationwide initiatives? We have recently faced the challenge of Apple's dating app investigation in Netherlands and ACM. So it's a question raised on whether or not this kind of particular initiative may face some challenges in this regard.
Yeah. Daniela, you wanna? Yeah.
I can quickly start maybe with the first question in relation to, do we expect this could be expanded to people outside the digital, or rather people and rather companies outside the digital field? And that was exactly what a lot of companies feared when the 10th Amendment in Germany took place. And indeed, I believe if you just look at the law and the wording of it, it could really, at least in Germany, also be much broader in scope, and it could relate to companies which on the one hand are active in data niches, as I said, and also it could still be used also in different sectors where there exist UMIPs, and that could, well, be banking sector or other sectors, maybe even from the old economy. I think that's a longer way down the road, but it is possible under the pure wording of the law. Sorry, Eduardo, passing over.
Yeah. Thank you. Yes, so I don't know, it's true that there have been discussions on this before on whether to have this kind of tools in different markets. Yeah, I think the digital market is the most obvious one because of the nature of the market, of the technology that is fast moving and with systemic failures, systemic problems in the market. I could imagine, for example, having this in pharma or I don't know, media. I don't know, because in the question they mentioned banking, retailing, media. I'm not sure, but yeah, maybe with this, maybe these digital regulations are going to be, you know, are going to provide lessons learned, and maybe regulators, legislators will pick this up to create new regulations in different markets.
Ulis, do you want to comment there?
Yeah, I think these are very interesting questions, and it's hard to add to what has been already commented by co-panelists. I think maybe only thing is that the very idea of this answering specifically the second question of developing such interventionist tools with such vague, full of adjectives, list of open-ended list of obligations. I exaggerate, but not just to convey the message more clearly, was precisely to combat this kind of shortcomings of our quasi-criminal nature of competition law, because, you know, we have managed to combine competition law enforcement with this ethos of human rights, where human rights and companies have also human rights, and thus all these companies have to be protected, and they know 1,001 way to delay and to circumvent. So basically, this kind of the accumulation of this dissatisfaction is kind of skepticism, while in the same time we as lawyers somehow understand the nitty-gritty of this, and it's bread and butter of our profession. So we have simultaneously greatest respect to colleagues who develop these arguments, because they are the brightest in the field, but simultaneously we disagree with the message, so to say. So DMA is precisely aiming to do it, and but this, I think at this point we have to pause and not to try to expand this idea further and think the more the better, because if we can say the more one or two enforcement actions, the better, but not with the DMA. DMA is more, you know, the idea of DMA is not to enforce the law. It's about compliance and about adjusting the system in a way where we should minimize the instances of non-compliance fines or systemic, let alone systematic non-compliance. But the only way we can underpin this working mechanism is by having heavy fines imposed pretty much indiscriminately if you make us really nervous, so to say, as enforcers. That's how I see the composition of different elements of this proactive ex-ante digital competition toolbox.
Thank you, Alice. I think we have time for one last question that we received here as well before we close, and the question is about effectiveness here. App case in the Netherlands and how difficult compliance was in that case, even after the decision of the Dutch competition authority. I mean, about in-app payments and compatibility there. There's a big discussion about enforcement effectiveness there. These are complex markets. Compatibility many times is one potential remedy, very difficult to implement, as we saw in the Dutch example. How do you see authorities dealing with these effectiveness problems in designing a compliance with these new tools and these challenges, given these examples of difficulties? We could also think about the Google Shopping remedy in Europe as another example as well, but your views on that.
Yeah, so, well, first, I think it's good, for example, in the DMA, we have this anti-circumvention provision, but also in terms of effectiveness, yeah, it's good to learn from experience and that's why it's really important to take into account the views of different stakeholders in order to have ideas on how effective. So what are the different options, the different measures that can be implemented, and yeah, and if the problem comes from the behavior of the gatekeeper that doesn't allow for compliance, it doesn't allow for the new measure to be implemented, so then we have the appropriate mechanisms for that. For example, the Article 6 Convention, also the systemic non-compliance provision in the DMA, and eventually the fines. So that's my reply to this question.
Thank you, Eduardo. Any thoughts from the other panelists that you'd like to share? Dani or Olis would like to share a last thought here? Yeah.
Maybe just a quick idea of what I really like about the DMA is, well, the compliance and that the companies are obliged to demonstrate compliance with the DMA on a yearly basis. And I think if that, because that also leads to this regulatory dialogue, which Eduardo mentioned, the two will, to some extent, be, I think, in the long run, entrenched and inclined. And I think if that was something which were to happen more broadly and globally, then also in terms of enforcement, you would have both the companies angle, but also then the regulatory angle joining up. And I think that could in the end lead to really a good and to some extent cooperative way forward.
If I might just one sentence to what Daniela just said and Eduardo before, I think the situations like we have with the Dutch Apple case were kind of triggers for adopting the ex-ante rules, because I don't see how you cannot you can play this game continuously with the DMA or the MCC, where the sanctions are, where the room for intervention is much quicker and much more widespread, and this will minimize or maybe even manage to avoid at all these systemic problems which we witness with ex-post rules. And basically what we can sense that you know, the different gatekeepers and different undertakings with strategic market status express their interest to kind of let us sit and decide what precisely we want from us. So this plea for certainty indicates that the tools are very well calibrated, that they started, being proactive with trying to somehow, rather than delay, and they are becoming much more quick and initiating the conversation. I think it's a very positive sign of the effectiveness of these ex-ante mechanisms.
Thank you, Olis. Any last thoughts, Toby?
Thank you, no.
Thank you. Thank you all. This has been a fantastic conversation. Thank you, Olis. Thank you, Toby and Dani and Eduardo. It's been really, really good to be with you here today and to learn with experiences in Europe. I really appreciate your time. And Eduardo had a problem here, but he's just reconnecting. Thank you very much. Apologies for some instabilities in my connection, but it was really, really good to have you all here with us today. Thank you for preparing and for being so available. We have like 4 different time zones here, so it's really a challenge to coordinate this, and it was really, really great to